Any mention?
Please, Lordship. Lordship, I beg to make a mention of item number 13.
Number
13. 2 weeks time, Lordship.
why?
Lordship, the conducting counsel JSL has disposed, Lordship.
No objection, Your Lordship.
On premier by the appellant, this is matter of 2 weeks.
Yes, Your Lordship, item number 14, 1-4. This matter is still under mediation, Your Lordship. Still no results as of now. Just let it list after 2 weeks. It's not settled, no? Not yet. 2 weeks. Still going. Still going.
Some more time may be granted for the settlement.
On premier by the parties, this is matter of 3 weeks.
Pleasure.
I will let you know.
May I please, Your Lordship? Item number 15 of the hearing list, Your Lordship. I am appearing on behalf of Mr. R. Gurung, Your Lordship. So, due to some personal difficulty, he is not here, Your Lordship. Item 15. 1-5.
Have you, who's appearing for the other side?
Yes, Your Lordship, I am appearing on behalf of R. Gurung, Mr. R.
No, but yes, who's for the other side? Have you?
Petitioner is Mr. B there. He is not around, Your Lordship.
You should get his consent.
Yes, Your Lordship.
Let it come in. Let it be called up.
Yes, sir.
In the meantime, if you happen to meet him.
Yes, Your Lordship.
Please, Lordship. Lordship, I beg to mention item 7 on behalf of respondent 4 and 5, Lordship.
Who's for the petitioner?
Kinjing was there. I informed Mr. Sindram outside, Your Lordship. I had just informed Mr. Sindram outside, Mr. Kinjing's junior.
He's not here.
I'll inform him, Lordship. Kindly have it after 2 weeks. Item 7. I just met him outside, Lordship.
No, have you got his consent?
Lordship, yes, I informed him, Lordship.
On premier by the Mr. SDEP for the respondent number
4 and 5.
4 and 5. Received not objected to by the petitioner. Matters adjourned. This is after 2 weeks.
Much obliged.
Right, please, Your Lordship. Lordship, I beg to mention item number 11. Lordship, learned DSGI is on sanctioned leave, Lordship. I pray for 2 weeks' time.
No objection, Lordship.
You are on behalf of who?
Respondent, Lordship, Union of India, Lordship.
Okay. Prayers made on behalf of the learned DSGI who is said to be indisposed. Prayers made seeking accommodation on behalf of him who is said to be indisposed. Received not objected to by Mr. Learned Counsel for the petitioner. Matters adjourned. This is the matter after 2 weeks.
Much obliged, Lordship.
May it please, Your Lordship. Lordship, I beg to mention item number 12.
You're for?
We're for the state respondents.
Who's the appellant?
She has not come. In fact, she had told me she wouldn't.
You got her consent?
Yes, she was the one who wanted time, but since she's not here, we are praying for time.
On pray made by Mr. Jain Rija, letter G for the respondent. This will not be objected to by the appellant. Matters adjourned. This is the same after 3 weeks.
From daily list, item number 1.
Lordship, this is that anticipatory bail application, Lordship. On the last occasion, the state, Lordship, senior advocate has produced this order of the recent order. Lordship, in my humble submission, this order is just it's an arbiter, Lordship. It is not a direction per se, Lordship. Here, because the issue is still pending, and Lordship, they have not decided on the issue whether the High Court has jurisdiction can take up bail, anticipatory bail matters, Lordship. It's still pending. In fact, there are contradictory judgments passed by the coordinate benches of the Honorable Supreme Court and various High Courts, Lordship. So, in view of the matter,
See, Mr. Tanda, I think propriety, you see, demands that
Lordship,
there is no harm for you to, to approach the trial court.
Lordship,
If you are, given your relief, well and good. If not, you can still come before this court.
Lordship. Otherwise, what I was submitting, Lordship, since it's a concurrent jurisdiction, Lordship,
we understand, but
Concurrent jurisdiction is there, no?
Like you said, this is how things have proceeded before the apex court.
Lordship, and the issue is still pending, Lordship. So notice has been issued. So respective parties, Lordship, are to come forth and give their views in this particular matter, which my learned senior has produced. So it is not a judgment. Otherwise,
we are not going to the merits of that.
Lordship,
we just look at what is on the face of it.
Lordship.
Paragraph 6 is the relevant, Lordship, of that order.
What I was saying, Lordship, if Lordship is inclined to entertain this,
you withdraw it and file it before, with liberty to file a fresh one.
Lordship, in that case, Lordship, may have it tomorrow, Lordship. I'll take instructions and then get back. Lordship.
Made by Mr. S. Under Learned Counsel for the petitioner. Let us adjourn. This is him tomorrow.
Lordship.
Item number 2.
Lord, in this case, I'm appearing. I have an instruction that they could not locate the new address of the respondent number 2, that is Dr. Subha Datta, my lord. In that case, my lord, we will have a paper publication of the notice in West Bengal, my lord.
You are paying for?
For respondent 3 and 4, yeah.
3 and.
You don't know, you are not related to this person?
We don't have, this is the only address that we also have here.
Well, actually, they were also appearing in the trial court, my lord, from their chamber only, my lord.
On his behalf?
They can provide the address, my lord.
Your Lordship, I've seen instructions also, Your Lordship. This is the only address that we have, Your Lordship.
Only on this
they
issue,
may be.
See, only on this issue we are lingering for so long. See, Mr. Singh, publication in newspaper.
Yes, my lord.
Publication in newspaper, it should be the last resort, in a sense
Option.
that.
Yes, my lord.
Practically, it serves no purpose. You can never say whether this person will indeed, look or go through that paper or not, whether he'll know that notice has been issued. It is just to comply with the provisions of law. Practically, it doesn't affect anything.
My lord, my humble submission is that the counsel appearing for the respondent number 3 and 4 were also connected with Dr. Subha Datta, my lord. They are from their chamber only. The counsel was appearing, my lord. They can provide the address. If they can contact them, it will be the convenient for this on the court also.
It will be incumbent for you also.
Because, Your Lordship, I've seen instruction, Your Lordship. This is the only address that we have, Your Lordship. Because
try, you see, address may be there. You see, you're not talking about the postal address. You may have his phone number. You may have his contact number of his relatives. Whatever.
I'll try, Your Lordship.
Try.
Yes.
After 2 weeks, my lord, let them take instruction.
Mr. B.K. Singh, Direct Counsel for the petitioner's appellant, is present and has submitted that in spite of continuous effort to trace out the proper and correct address of the respondent number. Respondent number?
My lord, respondent number 2, Dr. Subha Datta.
Respondent number 2, Dr. Subodh Datta. The notice could not be affected. It is finally prayed that this court may allow issuance of the said notice by publication in any newspaper, local daily newspaper, which is circulated widely in the place of residence and in the place where the residence of the said respondent 2 is said to be located. Mr. Leonard Counsel for the respondent number 3 and 4 has also submitted that some time may be allowed for the counsel to try and find out the correct address of the said respondent 2 and to convey such information to the appellant. In such a situation, this court would allow the appellant to try and find out the correct address of the respondent number 2 before before publication of newspaper of notice in the newspaper is carried out. Accordingly, as prayed for, this is matter after 3 weeks. Please, fine. If you do that, in the meantime, he will take steps.
Yes, my lord.
Item number 3.
Please, Archie. Archie, I'm praying for further 2 weeks' time to file my paper book.
On plea made by Ms. Leonard Counsel of the appellant seeking some more time to file paper book. Prayers allowed. This is matter after 3 weeks.
Item number 4.
Your Lordship, my client has gone to the police station. He is cooperating, so he is in any way not running away, so he will cooperate in future also. So in view of this, I hope the CD has come, Your Lordship.
My Lord, it has come, along with the status report. My Lord would remember this is a case where the Sessions Judge has rejected the anticipatory bail after perusal of the same.
Yes, so what is the case about?
It is abandonment.
It's an abatement to suicide, my Lord.
Oh, abandonment.
Suicide, abandonment of suicide.
What is the stage of the case?
The investigation is still going on as per the status report. Charge sheet not filed, my Lord. And my Lord, he has been absconding each time he is on interim bail. He comes to the police station and again absconds.
That is not the way he went and appeared, Your Lordship. He is not absconding. When he is called, he always cooperates.
My Lord, may kindly see the status report.
When did he last appear?
On the 3rd.
Because
immediately after the order. On the 3rd he went to the police station, and I was informed that
On the
they
3rd?
talked on the 3rd.
After he got the interim bail from this honorable court, my lord.
Even
So,
before
my
that
lord,
also he appeared, your lordship.
again, once he was given interim bail by the learned
Naturally,
sessions judge.
That is the
That's
purpose.
what.
That is the purpose for for pre-arrest bail. It is based.
That's it.
It is based on apprehension of arrest.
My lord.
Once interim protection is there, there's no apprehension.
My lord.
Where is the noting of the IO?
If my lord
His
may,
statement was
can-
recorded.
in the status
They
report,
have
it's
not
very clear,
asked
my lord. It's a
anything when
short.
he came on the 3rd. They talk nicely, and
My lord, may kindly come to page 3 of the status report. Furthermore, I received a copy. That paragraph ends with the sentence, and on 3/9/2025 at about so and so appeared at the PS and produced his copy of interim bail. Now, my lord, just one thing I wanted to point out, page 2,
Yes.
3rd para from the top. Further, during the course of investigation, a team led by ABSI so-and-so was prepared and deputed to Tura West Garo Hills in search for the absconding accused, Shri Brayando C.H. Mara, alias Jaksrang, but he was not found at home. However, deputed so-and-so learned from the family members that his actual name is Shri Jaksrang C.H. Mara and his wife's name is so-and-so, and none of their family members were aware of his self-proclaimed name. So this is a fact that came out during investigation, that he had changed his name while he was. So the complainant was not aware of the correct name, and the family members did not know that he had changed his name. And in the last paragraph, my lord, so our ground for objecting is that the statements recorded under 180 BNSS clearly show his involvement, and investigation is still going on. And he once in a while appears, and then again he does not. So therefore.
But I believe the statement of the complainant has been recorded.
Yes, ma'am. Complainant has been recorded,
And maybe how many witnesses have been?
My lord, complainant, the deceased's mother, and 2 more, my lord, if I'm not wrong.
Where is his statement?
Page 18, my lord. Page 18 of the CD.
His
we have marked.
Page 18.
The complainant's statement is at page 18.
The statement of the petition. The statement
accused.
Of the petition? Yes, statement of the
accused. My lord. It's page 24.
When he appeared on 3rd, isn't it?
I think this must have been recorded before that, my lord, because he appeared even when
before that also he appeared, your lordship.
Oh yes.
So Melody admits that they were in a relationship.
Heard Mr. Someone, letter counsel to the petitioner. Also heard Mr. Miss.
Yes, fine.
And Leonard GA for the state respondent. Leonard GA has submitted that on being directed by this court, the copy of the case diary connected to William Nagar Women PS case number 14/2025 under section 108 PNS has been produced before this court today. It is the submission of the learned J that the petitioner applicant has since the day the FIR was lodged was found missing in spite of diligent effort made by the police to locate him. It is only when he was granted interim bail on an application filed for grant of anticipatory bail before the Sessions Court at Tura. Is it Tura case?
William Nagar.
William Nagar. That he appeared before the IO and his statement was accordingly recorded. However, the trial court, on consideration of the facts and situation prevalent at that point of time, by order dated 19/8/2025, had rejected the prayer for grant of pre-arrest bail, anticipatory bail. It is further submitted that on the petitioner approaching this court with a similar application for grant of anticipatory bail, this court had in the interim restricted the police from arresting the petitioner, and accordingly once again the petitioner has appeared for the IO. However, on perusal of the case diary, what is apparent is that the petitioner is very much involved in the case and his complicity being evident. Therefore, at this point of time, he may not be allowed to be enlarged on bail if arrested. This petition deserves no merit and the same may be rejected. Order submits the GA. Mr. L.M. Sangma, learned counsel for the petitioner, on the other hand, has submitted that it is not the intention of the petitioner to evade appearance before the IO. However, because of the apprehension of imminent arrest, he was compelled to file application before the court seeking grant of anticipatory bail. though it is admitted that similar application was rejected by the learned Sessions Judge. However, the petitioner is now before this court with a similar application on the ground that the apprehension of arrest is still present, and because of this application has been preferred. It is the further submission of the learned counsel for the petitioner that pursuant to this court's order dated 1/9/2025, wherein he was granted interim bail, the petitioner has appeared for the IO on 3rd September 3/9/2025.
Yeah. And also before that also appear, Your Lordship.
That is there. On 3rd, his statement was not recorded. I mean, that was only...
Yeah, he appeared, but they have not asked him anything.
Appeared and he was... Accordingly, it is prayed that this petition may be allowed with any condition to be imposed by this court, which will be adhered to by the petitioner. This court has considered the submission made by the parties and has perused the petition as well as the case diary. What is apparent is that the IO has indicated in course of his investigation that there is evidence against the petitioner being involved in the case where one minor girl, daughter of the complainant. She's the daughter of the complainant. She was the daughter of the complainant.
Yes, Your Lordship.
Daughter of the complainant had allegedly committed suicide. The said act having a direct nexus to the relationship, to the illicit relationship between the petitioner and the deceased. As such, there is the possibility of the petitioner being every possibility of the petitioner being held responsible was the abetment of such offence, for such an act. The fact that the case is still under investigation and charge sheet not having not yet filed, the investigating officer is therefore allowed to complete his investigation. However, it has been submitted before this court that till date the IO has noted down the statement of the complainant and some witnesses vital to the case, and also the statement of the petitioner herein. At this point of time, in view of the fact that the IO has come to a finding that the petitioner is involved in the matter, therefore the fact that the petitioner is apprehending imminent arrest is present. This being the case, there is cause of action for filing this instant application. It is also to be reminded that more often than not, the principle of bail in criminal jurisprudence is that, I quote, bail is the rule and jail the exception. At this juncture, this court finds no reason for the petitioner to be incarcerated in custody if he commits himself to the process and would ensure and would undertake that he will not abscond or tamper with evidence or witnesses, etc. Since these mechanisms are well placed in the system, at this point of time, this court is inclined to allow the prayer made in this petition. Accordingly, if in the event of his arrest in connection with the said Viranagar Women PS case number so and so, the petitioner is to be enlarged on bail on the following condition. I'll give those usual condition. Bail will be set at 30,000. I took a last zero. Needless to say, violation of any of the aforesaid condition would allow the prosecution to file an application before the trial court for cancellation of the bail. Petition disposed of. Anything else you want to say, Ms. Ann?
My Lord, I'm not very clear about this, but when this court is granting the bail, then should it be correct to approach the trial court for cancellation? Is my concern.
No, because you see, the trial court would be in constant touch with the IO. You know, report, remand, everything has to be filed before the IO. So instead of coming back to this court, it would be incumbent upon the, more often than not, we direct the trial court to, or the prosecution to approach the trial court.
Ma'am. Thank you.
Highly obliged, yours.
Item number 5.
May it please your lordship. Your lordship, we have filed the status report as per your last order.
Where is that status report?
It was filed on the 10th, your lordship, of this month.
You file it by way
Of an affidavit, your lordship, yes.
You've received copy of the...
Lordship, I pray for 1 week's time to seek instructions, Lordship, on...
What have you said in your report?
Lordship, this status report states that we require some more time, your lordship. Because of the monsoons, the physical verification of the land could not be carried out.
Okay. That was a prayer also. You know, last time...
Yes, your
you had said
lordship.
the same.
Yes, your lordship.
Lordship, 1 week's time may be given, will come...
We should give them time. Please let them complete the process. See, you never know. It may come in your favor.
Lordship.
So if that is the case, then you know, this whole exercise becomes
Lordship.
You know, pointless, so to say. Miss Leonard GA has submitted that the respondent has filed his status report by way of an affidavit. The filed status report dated 10/9/2025 by way of an affidavit on behalf of the respondent number 1, 2 and 3 respectively. Mr. Letter Counsel for the petitioner, on the other hand, has prayed that some time may be allowed for the petitioner to respond to the said affidavit. On praying the same is allowed. This is matter up to 1 week.
1 week, Lordship.
1 week.
Obliged,
Highly
Lordship.
obliged.
Item number 6.
May it please your lordship. Lordship, in this matter, we were supposed to file an affidavit, lordship, a paper book.
Paper book.
A paper book, lordship. Lordship, I'm praying for just some more time, lordship. There are certain documents that we have been unable to receive, lordship. We've applied for copies from the registry, lordship. It'll take a little bit more time to obtain those documents.
This is 2022 matter.
Lordship.
Miss Land Counsel for the petitioner has submitted that in course of preparation of the paper book by the petitioner, certain certified copies are required to complete the said preparation. Therefore, it is prayed that some more time may be allowed for this exercise to be concluded. Mr. Iskari additional PP appears for the state respondent. Prayers allowed. This is matter after 3 weeks. By then you should copy, otherwise we'll proceed as it is.
Lordship. Highly grateful, lordship.
Item number 8.
May it please Lordship. Lordship, here, Lordship, we have filed a service affidavit, Lordship.
What
Because
is
as per the last order, Lordship,
Here, the respondent number 4 and 5 have been substituted in view of the fact that the respondent have expired. Also. So we have filed our substitution application. The respondents have been substituted, and we are supposed to file the service affidavit to show the status of that.
You have filed?
Yes, Lordship. In the last occasion, we have filed, and it's before your Lordship. So that respondent is supposed to enter appearance.
Who is it?
Respondent 4 and 5, Lordship.
No, you have 4 and 2.
I'm for respondent number 3. Respondent number 3.
3.
I think 4 and 5 are yet to.
And who's for 4 and 5?
Number 4 and 5, they're yet to appear, Lordship. And we have already filed our service affidavit, bringing on records that the service have been completed.
So we'll wait then. Give them time to appear.
Lordship. Matter can come after 2 weeks, Lordship.
Mr. Direct Counsel for the petitioner has submitted that notice have been issued upon the respondent. They have been issued upon the legal heirs and legal representative of the respondent, deceased respondent 4 and 5. The service has been affected, and the affidavit of service has also been filed in this regard. However, no representation has been made on behalf of the said respondent 4 and 5 till date. It is prayed that some more time will be allowed in this matter. Accordingly, matters adjourned to allow the respondent 4 and 5 to appear before this court. This is matter of the 2 weeks.
You be obliged.
Item number 9.
Sorry, you ready? No, we'll take it. May I please your lordship? I am for the petitioner. The conducting counsel of this particular case was unable to attend this course proceeding today for personal difficulties. So my humble prayer before your lordship to adjourn this matter for today and may fix another date for after 2 weeks, your lordship.
My lord, I'm appearing for the corporation, my lord. Respond number 2 and 3. I have no objections.
What is this matter about?
The matter is about the compensation of the appellant actually.
In case of electrocution, you should receive compensation from MECL. And for respondent number 1,
okay. So how soon? When do you want it fixed?
After 2 weeks.
Mr. Direct Counsel for the petitioner has sought for accommodation. On grounds of personal difficulty. The same not be objected to by the respondents. The learned counsel for the respondents in attendance. Pray aloud. This is matter of the 2 weeks.
Much obliged.
Item number 10.
Who's for the petitioner?
This is the case where the patta has been cancelled by the district council and they are before this honorable court against that, my lord. Mr. A.S. Siddiqui, senior counsel, his chamber was appearing for this matter, if I'm not mistaken, my lord.
Maybe he doesn't know that this matters.
Probably he is not aware that the matter. So let it come, my lord, after 2 weeks, my lord.
None appears for the petitioner. Mr. Asdef and Mr. Tidhar appears for the respondent number 1. All the respondents respected. Mr. Asdef, Learned Counsel for the respondent number 1 to 3. Mr. Tidhar appears for respondent number 4 to 8. Accordingly, as submitted, list this matter after 2 weeks.
Hello.
Item number 15.
The appellant is Karmosunt and Bidep.
None appears for the appellant. Mr. H. Abraham. Leonard J. appears for the respondent. On pre-made, list is matter up to 3 weeks.
Item number 16.
Thank you, Your Lordship. May I audible, my lord?
Yes, Mr. Sakia.
My lord. My lord, on the last occasion, my lord, the government has raised a point, my lord,
Yes.
regarding maintainability of the bail application. And my friend has filed one submission, written submission. I have received the copy, my lord.
Yes.
Now, Your Lordship, kindly, first thing is that, my lord, in the Meghalaya High Court rules, my lord, I have the copy in my hand. There is no procedure has been, my lord, laid in the rules, my lord, as to filing of the bail application. Totally silent.
Okay.
And there is also, my lord, I have not come across any judgment of the Supreme Court or High Court, my lord, any of the High Courts, my lord, that a father cannot file bail application or the vice versa, my lord. My case is that Your Lordship kindly goes through my petition, my lord, paragraph number 2, my lord. Paragraph number 2.
May I please, Your Lordship? Your Lordship, since the conducting counsel is indisposed, if the hearing is supposed to be today, then can you accommodate some more time, Your Lordship? Maybe tomorrow?
Who's conducting counsel?
The conducting counsel is A.H. Kharwanlang and N.G. Shillai.
But you are there. Yeah. This submission has been filed by you.
On behalf of A.H. Kharwanlang, Your Lordship.
The judgment that has been cited in the written submission is not retracted in this case at all. In paragraph 2 of my bail application, it has been clearly stated that bail application has been filed by the father on behalf of the accused person. If Your Lordship goes to the paragraph number 2. And there is no bar, my lord. Under the Juvenile Justice Act, my lord.
See, Mr. Sakia,
My lord.
it may have been filed on behalf of the accused, but you
My
could
lord.
have just made us one averment to say that
My lord.
you have been authorized. See, just one averment, one line to say that you have been authorized to file the bail application
My lord.
on behalf of the accused. That would do.
Authority is always there, my lord.
No, authority.
The father, my lord.
Yes, naturally, father, but we
My
don't know.
natural guardian, my lord.
We don't know.
And there is categorical statement in paragraph 2, my lord.
True, but he
And
said,
under oath, my lord, by swearing an affidavit that under the Oaths Act, my lord. I have stated everything. Paragraph 2 itself, my lord, Lordship kindly peruse.
Yes,
The petitioner is the father of the accused. And he filed this bail for and on behalf of the accused person who is in jail in custody since so and so, my lord, in connection with PS number so and so. That means, my lord, he was duly authorized, my lord, being positioned as a natural guardian, my lord. And under the Juvenile Justice Act, my lord, it is the next of kin or any friend, my lord, who can file application on behalf of the juvenile, my lord, since juvenile cannot file bail application, my lord.
well, he is not.
That principle may be applicable in this also.
He is not a juvenile.
He is not a juvenile, but the power of the natural guardian or the friends, my lord. Even an advocate can file a bail application on behalf of a person.
True. You see, that is, in fact.
My lord.
In fact,
and the rules is totally silent. High Court rules is totally silent.
See, Mr. Sakia, in what you see, what I could understand is this: anybody can file any application on behalf of the accused, provided he or she is authorized. See, that is what is required. See, it should come to the knowledge of the accused that an application for bail or whatever application has been filed on his behalf, and he can just convey, you see, he can just convey that authority through the jailer.
I have the Ukalat Nama. All difficulty has been arisen when the, my lord, the registry has objected, my lord. This is the Ukalat Nama filed by the, my lord, accused person. And in the earlier petition, it was filed in the month of, my lord, August, my lord. This Ukalat Nama was attached, my lord. But the registry objected, then I returned back the Ukalat Nama, my lord.
Your Lordship, even in
It was filed on 2nd of August, my lord, 2025.
point number 4.
When the registry has objected, my lord, then I withdraw the Ukalat Nama, my lord, of the accused person.
Where is your Vakalnama? You have a copy of, you have the Vakalnama with you?
Right now, I had the original Ukalat with me, man. After getting it back from the registry.
But where's the copy
of the Honorable Court? My lord, copy was not there, my lord. My friend, one advocate Pala was there. Perhaps he was present. He is present in the court, my lord.
No, but does he have?
I can send a photocopy in his WhatsApp, my lord, so that he can place it before them.
Yes, miss. What do you want to say?
Your Lordship, even in point number 4 for written objections, we already mentioned that they haven't been authorized. There was no record that they have been, the father have been authorized, Your Lordship.
But since, see, what Mr. Sakia said is correct. You see, even a Vakalnama can be considered an authority.
Yes, my dear, power of attorney. Mukalatma is nothing but power of attorney.
But it's not on record, Your Lordship.
Yes, it's not on record because, okay, we'll not say anything. Maybe there was some communication difficulty, I would say.
Lordship, then let it come tomorrow.
Lingering on this point for so long makes no difference. We've been.
My lord, personal liberty is concerned, my lord. Pendency is no more. And tomorrow is the date fixed for, my lord, before the trial court.
No, that doesn't matter. Have you filed a written counter to this, submission?
I think, my lord, no counter is required in this case, man.
For example, this point B, no change in
Point B.
factual
My
scenario.
lord, order, the rejection order itself, my lord, shows, my lord, the change of circumstances. Page 47 and 48, my lord. The bail was rejected on the ground that unless and until the victim and the informant is examined, my lord.
Yes. By now.
There is a change of circumstances.
True.
The lordship may dispose it of, my lord.
No, but.
No.
Come up tomorrow.
She's saying her senior colleague is not here.
My lord. Then your lordship may fix it on Thursday, my lord.
Thursday or tomorrow?
Thursday is a holiday.
Tomorrow will be difficult. I am the conducting counsel of the trial court, my lord.
Then.
The after.
18th of September, my lord.
18 is a holiday.
I will personally present.
No, 18 is a holiday here.
18, then 19?
19.
My lord, I will personally present before this.
And you bring that Vakalnama?
My lord, it is with me, my lord.
Or if see, Mr. Saikia, if possible, you have these 2-3 days. You have these 2-3 days with you. Get some authority from the accused.
My lord, yes, that can be, my lord.
That would solve all the problem.
That can be, my lord. That can.
Miss GA has submitted that written submission on behalf of the respondent has been filed. Mr. PJ Saikia, learned counsel for the petitioner, has submitted that this matter may be finally heard on Friday, as he will be able to appear physically in court. Accordingly, as prayed for, this is matter for the hearing on 19th.
Lordship also kindly observed that the respondent, my lord, should not take any time.
No, no. If they take time, I'll pass the orders.
All right. All right. Deeply observed.
Yes.
Your Lordships, I beg to mention item number 12. Your Lordship, I'm being led by the Additional Advocate General, Miss T. Yangi, Your Lordship. She has some personal difficulty today.
She was
I'm
here.
praying. She had to leave, Your Lordship. I'm praying for 2 weeks accommodation.
May I please, Your Lordship? I have filed a miss case. It is the most urgent, so maybe call for the record.
What's the miss case about? What is this case about?
Miss case regarding that they have submitted, they have possibly obtained my signature. Later on, I come to know that it is my resignation letter from the post of President Secretary of BSc.
BSc?
Yes. Then I filed the FIR. Then original copy they have given me. Maybe somebody photostat copy they have given to the BDO. So BDO has accepted it and dissolved my BSc, my lord.
Your Lordship, that FIR that was filed by them was also withdrawn. They themselves have withdrawn that FIR.
That is the reason, my lord. Original copy is with us, my lord. They have written it and it is with us.
No, tell me, what is this case about?
This is they are coming against the order of the single bench.
Yes.
The single bench has dismissed their case because for concealing of the facts. Now what happened is that they have collected all the signatures of the VSC, the job card holders, and with the signature of the VSC holders, they managed to held a meeting and then approve the VSC character. Then later on, we filed the RTI. I am the private respondent. Once we filed the RTI, BDO has disclosed all the documents. Then we filed the FIR against them, against the appellant here. After filing the FIR, police have conducted the inquiry. After conducting an inquiry, it was found that they have fraudulently taken all the signatures, and then they themselves have compromised before the SP and official in charge. And after the compromise order, after the compromising, this letter of compromise sent to BDO. The compromise, on the basis of the compromise, BDO has issued a fresh notice for fresh election. Then election was conducted. After the election, the new VSC and even appellant was there in the election very much, and the proper procedure was taken. As per the procedure, election VSC was held, and then we are the new elected VSC secretary and president, and then they are now no more, and they filed a case against the dismissal, or the case was dismissed only on the ground of misleading and misrepresenting the court.
Okay.
That was their
merits will be looked into.
Yes.
Since today they have sought for
yes, my lord. So only for my prayer that the call record that will be the
since you see.
Yes, adjournment.
Adjournment has been sought for.
Yes,
we will not go into that.
Yes. They are mispresenting the fact.
No,
anyway, my lord.
They are not coming in clean.
Okay, so we'll take the matter up after 1 week then.
Your Lordship.
Yes,
on prayer made by Ms. Reddy, seeking accommodation on behalf on the ground that the Leonard AAG, Ms. Yangi, is indisposed. The same not be objected to by the appellant. That is adjourned. This is after 1 week.
Obliged, Your Lordship.
May I please, Your Lordship, I beg to make a mention part 2 of the hearing list, item number 6, 7, and 8, Your Lordship. 6, 7, 8, this is a connected matter. I've informed the other side, Your Lordship. If this matter may be taken up after 2 weeks.
This matter has been heard.
It's been heard by the appellant. It's already concluded.
Appellant finished?
Yes.
We just want to do some little research. We want to find out some citation here, Your Lordship.
Mr. H. Abraham Leonard G. has sought for accommodation on behalf of the respondent, state respondent, on the ground that he is not prepared to be heard today. This prayer has not been objected to by Mr. Leonard Counsel for the appellant. Accordingly, matter is adjourned. Let's the same after 2 weeks.
Hello, Your Lordship.
6, 7, 8.
6, 7, 8 years, Your Lordship.
Lordship, I'd like to mention item number 4, my lord. Dr. Puja is on the appellant side. Item number 4 could not inform.
May it please, Your Lordship. Lordship, in this matter, I have been engaged as legal aid counsel. Lordship.
I'm praying after 2 weeks, my lord.
Legal aid counsel?
Lordship, I've been newly engaged.
But Dr. Puja is also legal aid counsel.
Lordship, she's withdrawn from this matter.
Okay. So what is your prayer?
Lordship, this matter may come up after 3 weeks. You'll give me some time to prepare the matter, Lordship.
Ms. Leonard, Legal Aid Counsel has submitted that she has just been engaged in this matter and has sought for time to prepare for the case. Accordingly, as prayed for, place this matter to 3 weeks.
Highly obliged, Lordships.
Lordship, I beg to mention item number 9 as well, my lord. In 9, my lord, the counsel for the Legal Aid Council has, according to them, they have already submitted the written argument. So what we are proposing is that we need some time to, because we have to start the case afresh, my lord. My lord perhaps has, we are contemplating that we will open the case, my lord, fresh, and we'll argue, my lord, on behalf of the respondent. Since they are saying that they have concluded by submitting the written argument, and we are saying that we want to do oral argument, then thereafter, if required, we will file a written.
No, you've already.
I have filed my written argument.
So you have filed your. I mean, your argument, oral argument is.
Partly done, my lord. Thereafter, the court had directed us to file the written argument. I have filed my written argument in details, my lord. Comprehensive written argument I have filed.
So I am praying for 2 weeks' time, my lord. We want to.
Of course, once they complete my lord, I'll reply to them.
On pay made by Mr. S. Sangupta, Leonard Additional PP, seeking accommodation. Same not being objected to by Mr. M. Sharma, Leonard LAC. That is adjourned. This is after 2 weeks. This is 9.
9, my lord.
Deeply.
Lordship, I have similar prayer for item number 5, my lord.
Practically nothing is there.
Doctor, here also Dr. Puja, my lord. 5. So we are praying for some accommodation, Lordship, after 2 weeks, Lordship.
Yes.
No objection.
You are praying for appellant?
Yes.
No, Dr. Puja, she is also LSE.
Yes.
And the newly appointed Legal Aid Counsel in this.
Oh, you are newly? Yes. Should say so. I to Mr. I come to order even. Okay, 3 weeks.
Hello.
May it please your Lordships. Your Lordship, I beg to mention item number 10 and 11. Lordship, I'm praying that this matter may come up after 2 weeks, your Lordship, as Dr. Mozika is on leave.
Who's for the?
Your Lordship, it's.
You are for the appellant?
Yeah, I'm for the appellant, your Lordship. Mr. M. Chanda, we've already informed him.
Sought
Yes,
counsel?
yes, your Lordship.
Mr. Leonard Counsel has sought for accommodation on the ground that the Leonard DSGI is indisposed on grounds of personal difficulties. Accordingly, as paid for, this matter is adjourned. This is after 3 weeks.
Much obliged.
Hearing matter over.
Lordship, I beg to mention item number 3.
What?
It was heard from the appellant side, Lordship. This was on the last occasion.
I'm being led by learned.
Okay, you completed your.
Yes, yes.
The
Then
state has to reply.
after that,
because this is connected to the.
yes, another
okay.
appeal that was already heard from both sides, and matter is up for judgment.
This court is waiting for you to.
Yes, Lordship. Yes. We have.
I'm being led by the learned Additional Advocate General, Mr. Shulai. He's on sanction leave, Lordship.
He's on leave, Lordship.
A week's time, maybe.
Because from our side we have argued. Then if they after the argument rejoinder, if any, then only.
Premiered by Mr. Yar Khan, Leonard Counsel, Leonard J, seeking accommodation on behalf of Mr. N. Shulai, Leonard A.G., who's said to be indisposed. The same not being objected to by Mr. S. A. Sheikh, Leonard Counsel of the appellant. Matter is adjourned. This is after 1 week.
Thank you very much.
Lady list item number 1.
Please, my lords.
May it please the Lordship.
Yes, yes.
Lordship, before
lords.
before my learned senior counsel submits Lordship.
Who's Mr. Thapa or Mr.
Well,
Paul?
I'm assisting the. I am for the appellate.
Lordship, your Lordship, I pray for some accommodation, your Lordship, as the learned TSGI is on sanction leave, your Lordship. So I therefore
Well,
pray,
is that-
Your Lordship, a week's time may be granted, Your Lordship.
My lords, I'm conscious of the fact that my friend Mr. Mosika is on leave. I was only making a limited prayer. This matter actually, my lords, pertains to the transfer of the appellant before your lordships, my lords. So the learned single judge, my lords, in paragraph 6 has found, my lords, no infirmity with that. I would humbly submit, my lords, that this would require some examination by your lordship. So the appeal may be formally admitted. It can be kept next week when my friend is available, my lords, and the matter can be heard and disposed of.
Oh, this has been listed for admission, so they may have some
Yes, Your Lordship.
objection to that.
Yes, Your
But
Lordship.
let's the issue here. Otherwise, if your lordships permit me, I can just take your lordship very quickly to paragraph 6.
If in that
My
case,
lords
Your
would find
Lordship, this matter may come upon Wednesday, Your Lordship. This matter may come up on Wednesday, Lordship. Wednesday, Lordship. I'll request him to come through VC, Lordship.
Okay. So Wednesday was the point.
My lords, Wednesday is okay.
Who has filed this? What is this? Is the what is this?
This is an additional affidavit, my lord, we had filed to bring on record subsequent event, my lord, which has come up after filing of the appeal, my lord.
Post the appeal.
Post the appeal, my lord.
There have been some developments.
Some developments were there, so my lord.
That has been brought on record by way of this affidavit.
You've given them copy?
Yes, Lordship, we've received.
On premier by Ms. Learned Counsel, seeking accommodation on behalf on a ground that the Learned DSGI is indisposed. The same not being objected to by the appellant. Place this matter on Wednesday.
Wednesday.
17.
Much.
Obliged.
Obliged.
Item number 2.